using the statute, it was not clearly understood what it meant. The definition of likely did not come from the SJC until more than a year and a half later. It was in December of 2002. This is in April of 2001. It was not until December of 2002 that the Supreme Judicial Court in the Boucher case defined likely, and I brought part of that. Let me just read two sentences from it because I think it's important to understand that I think most judges, as I did, thought that likely meant more likely than not. And that, again, was found to be an error by the Supreme Judicial Court. Let me read from Boucher, again, which was not decided when I had Reese and Rodriguez, was decided a year and a half later. The SJC said in Boucher, likely is not defined in General Laws, Chapter 123A, nor is it understood to be a term of art requiring a specific and limited interpretation. It went on to say, we conclude that something is likely if it is reasonably to be expected in the context of the particular facts and circumstances at hand. So that's what they said likely was to mean. I think you can understand how that was not obvious to myself or to other Superior Court judges at the time that is what the SJC would end up saying likely meant. So we were all struggling to figure out what likely meant, and frankly, many of us were seeking to put likely into a framework that we know. We know more likely than not. That's what we use in every civil case. So what I did, again, trying to interpret what the statute meant, is to say that likely meant a person is more likely than not to commit a sexual act. So that's part of what I did. Now, the statute says that when you look at the definition of mental abnormality or personality disorder, it speaks about having a psychological condition that essentially compels the person to do something.
Although, Judge, I think that interrupting the rule about anyone who's molesting sexually a 6-year-old or an 8-year-old repeatedly over a period of time has that some kind of deficit. And I don't recommend the book, but anyway.
The actual literature is somewhat surprising in that the rate of sexual recidivism, even for child molesters, although obviously considerable and may vary by individual, is not as high as we think it is. It's not in the realm of 70-80%. It's actually lower than that, and so there are people who engage episodically in this conduct but may not. So it's and that's part of what this data illustrated, is that what we think we know about sexual dangerousness is not necessarily supported by the data. But part of what I was trying to do is to make a definition which allowed us to use the data concerning sexual dangerousness. What that data essentially does, and it's what's called the Static 99, which is what Hansen presented, and is now used by the Sexual Offender Registry Board to evaluate dangerousness when they do level 1, level 2, level 3. They use the Hansen data to categorize somebody as a level 1, level 2, or level 3 offender. I was trying to have a definition which would allow the data to be used. The data differs depending on what length of time we're speaking of. If you were to ask the question, what is the likelihood that somebody will be convicted of a speeding violation? Well, for each of us, if we say within the next year, that's going to be much lower than if we say within their lifetime. So the issue of how dangerous somebody is really depends upon what length of time we're talking about. And I thought that if we had some period of time, it would allow us both to recognize that this mental disorder or this mental abnormality or personality disorder is supposed to be so severe, that's so compulsive, that somebody would have to, in a reasonable period of time, be likely to commit it. And if we gave a fixed period of time, we could then use the data to be able to place that person in a range of dangerousness. So that's what I was seeking to do, was to basically have a definition of likelihood that allowed us to use the data on sexual dangerousness so that we could categorize people in terms of how dangerous they were. Clearly, this law was meant only for the most dangerous sexual offenders. We don't have room to put everybody who's ever committed a sexual offense at Bridgewater. We'd be filled up within a year. would accomplish a definition that judges understood, juries understood, because juries would have to apply it, and that could use the date. And again, I was found to be in error as to that. But that's at least what was my frame of mind, given the state of the law back then.
And you can see why the prosecutors, again, in terms of sexually dangerous person, I know you've been dealing with business litigation the last 4 years, but was concerned and have those concerns.
Right, I certainly understand that, and I also acknowledge that the SJC reversed me. So on that, the SJC had a different view. I, of course, followed that view after it came down. But I do ask you to consider that the law was really was developing. It was really at a very early stage in that spring of 2001. That's why so many of these issues were so difficult, because the standards really had not yet been articulated by the appeals court and by the SJC.
Thank you. I do have to go back. You know what? Do you want me to move on a little bit and then come back? I'll yield and allow you to continue.
Come down.
I'm going to yield at this moment.
Councilor.
If you excuse me, Judge Bennett, as a matter of personal privilege to depart from this hearing, today as we meet the governor and our constitutional officers are attending a funeral for a hero, Boston firefighter Lieutenant Kelly. And as a citizen and as a firefighter's widow, I would ask that we all stand in silence or in silent prayer